The peculiar thing about justice versus injustice is that oftentimes it's not so much about the results as it is about the process itself. So I promised you all a follow-up on my vlog where I analyzed and broke down the decision granting the Washington Post's dismissal of suit against Nicholas Sandmann's defamation lawsuit. If you haven't seen that video yet, I'll link it right here. Go have a watch before you watch this particular video. For those of you who are new to the channel, I am a Montreal litigator turned YouTuber, although I still do law, but I do these things called vlogs where we analyze and break down things that are going on in the news in terms that can be understood by lawyers and non-lawyers alike. And when I read the decision granting the Washington Post's motion to dismiss of Nicholas Sandmann's defamation lawsuit against them, I knew there were going to be tons of people who were going to need that decision broken down so they can understand what was going on and come to their own conclusions. And in reading the comments in the comment section, I noticed a ton of recurring themes, questions, issues coming up in the comment section, and I said I'll have to do a follow-up to address those questions and concerns. But before we get into that, I'm going to give you an anecdote from my own practice as an attorney. I had a client who was involved in a shareholder dispute in an online business. Now, everything I'm telling you is entirely public, but I'm still not going to give you sufficient information to identify any of the parties because the identities don't matter, the details don't matter. It is the general principles that came out of this overall experience that is relevant to the discussion that we're having right now. It was a shareholder dispute in the context of an online business, so things like SEO and Google ranking were very important to the business. We go through the entire litigation process and we finally come for our 2 days of trial. And in Quebec, the Superior Court judges rotate, so you don't know which judge you're going to get for any particular trial, and for this particular trial, we ended up with a judge who was semi-retired, 75 plus years old, who specialized in family law. And why is this all relevant? We are coming to the trial on the merits, our day in court, the embodiment of justice, so that we can present our case to the judge and have the judge adjudicate on who is right and who is wrong. We're talking about an online business. We're talking about terms like search engine optimization, Google ranking, Facebook ads, the internet, things that a lot of people are not fully familiar with, let alone a judge who specializes in family law. I am a lawyer. I consider myself to be of the younger generation that grew up with the internet. It took me quite a bit of time to appreciate what search engine optimization was, how it impacts online business, and how it is essential to the growth and success of an online business. And here, after waiting however long we waited to get our trial date, while we're presenting our evidence, while we're trying to make sure that this judge understands the nuance, the detail, the importance of search engine optimization as it relates to Google ranking, Facebook ads, online success, after 20 to 30 minutes, this judge who specializes in family law says, "I think I understand enough, move on." And after a 2-day trial, the judge deliberates overnight and renders a decision the next day, which is not favorable to my client. Obviously, we were frustrated with the outcome of the decision, but there's a difference between being frustrated with the outcome of the decision and being frustrated with the process in which we do not feel that we were treated equitably. And it was at that time that I fully appreciated that justice is not a question of getting what you want in a judgment on the merits. It's making sure that you had a fair and equitable process in order to be heard. And bringing all this back to the dismissal of Nicholas Sandmann's defamation lawsuit against the Washington Post before they have even had their day in court, on what is referred to as a Rule 12 motion to dismiss, meaning that the entire claim did not set out a valid statement of claim that the plaintiff had against the defendants. Imagine that. It's not as though the lawsuit was dismissed after a hearing on the merits where the judge said, "I have heard witnesses, I have seen evidence, and I do not believe that there was defamation." Or, "I believe there may have been defamation, but I don't believe the damages." Or, "I believe that there were some damages, but don't believe there was $250 million worth of damages." It wasn't that. It was a dismissal on a procedural rule on the basis that the entire statement of claim did not lay a valid claim that the plaintiff had against the defendant. No evidence, taking for granted the allegations in the claim, a judge came to the conclusion that there was no valid claim to be made in that lawsuit. It's not so much the outcome that reeks of injustice, although guaranteed that if a judge or jury had come to this conclusion as well, a lot of people would say that this is nonetheless still an injustice, but at the very least, the person would have had their day in court, evidence would have been adduced, and they would have had an equitable process. It is the process itself that reeks of injustice that is causing a lot of people to ask a lot of questions, as evidenced by the common thread of comments and questions in the comment section of my original breakdown of that judgment. And let us address some of the commonly asked questions and respond to some of the frequently recurring comments. The judge has no business sitting on the bench and should be disbarred. One may vehemently disagree with the judge's decision, but that is what you have the Court of Appeal for. Judges don't get disbarred systematically because they render judgments which are overturned in appeal, judgments which are questionable or untenable. From what I understand, federal judges are appointed, and they are appointed for what is referred to as life. They only stop being judges if they retire, if they die, or if they are removed from the bench for poor behavior, which apparently happens like so infrequently it's not even worth talking about. And in Quebec and Canada, we have a very similar system. Judges are appointed, and they are appointed for life. And they are appointed for life so that they can maintain their judicial independence. But in order to be removed from the bench, it takes more than a bad judgment. It takes egregious, over-the-top conduct on or off the bench. And as angry as some people are with this particular decision, it's not cause for removing a judge from the bench. You have the Court of Appeal as a check and a balance, and then you have the Supreme Court as the ultimate check and balance, and hopefully the Court of Appeal remedies what are improper judgments to the extent that they are improper. And incidentally, while we're on the subject of the Court of Appeal, another comment that was coming up was straight to the Supreme Court. I think everyone has to appreciate that this is a preliminary judgment. This is not a judgment on the merits. Nicholas Sandmann is now going to have to go to the Court of Appeal to overturn the judgment granting the motion to dismiss by the Washington Post. That will only put the parties back in sort of the original state, whereby Nicholas Sandmann will get to go to trial on his defamation lawsuit against the Washington Post. It's not going to remedy the ultimate outcome. The judgment in question was dismissing Nicholas Sandmann's lawsuit on a Rule 12, on a summary motion to dismiss. No trial had occurred yet. So Sandmann will take it to the Court of Appeal, and if the Court of Appeal says, yeah, this judge got it way wrong, we're overturning that decision, all that means is that this matter is going to go back down to the first instance for a trial by jury. All that it means is that Nicholas Sandmann gets to pursue his claim against the Washington Post. It doesn't overturn any judgment on the merits because there was no judgment on the merits yet. So Nicholas Sandmann is going to appeal this decision. If the Court of Appeal says that judgment got it totally wrong, reverse the decision, send this back down for trial. Or the Court of Appeal says, no, we can't really find any errors in law to justify overturning the decision, then in theory, Nicholas Sandmann can go to the Supreme Court, but always on the original question of the dismissal of the suit and not on the actual merits of the dispute. So all of this procedural mess just to get back to the point one where Nicholas Sandmann can pursue his lawsuit against the Washington Post. A lot of comments jokingly or not so jokingly saying how much did the judge get paid, the judge is corrupt, the judge must have been bribed, etc., etc. This is the problem when there is not even the appearance of justice. And like I was saying at the beginning of the video, justice is not so much about the outcome as it is about the process. And when the process appears to be unjust, people start looking for explanations and justifications as to why there was this procedural injustice. They start looking for corruption. They start looking for theories to justify how it is that a judge could come to this decision, which is, to many, so patently unfair on its face that it's almost incomprehensible. People suggest corruption, people suggest bribery, people begin to look at the judge himself for political inclinations as to why the judge would render a decision like this. And they say, oh, look at that, the judge was appointed by Carter in 1977. Others might say, this is an 83, 84-year-old judge who's been on the bench for 40 years, has no idea what social media is, of course he got this decision wrong. And getting back to my anecdote from the beginning, that's sort of how I felt in my particular case. I was just trying to explain to myself and to my client how a semi-retired judge who specialized in family law could come to the conclusion after 20 to 30 minutes that she had sufficient understanding of search engine optimization such that she could assess the contribution of my client to the success of an online business and the value of his contribution to the success of that company. And it's not a question of rightly or wrongly, it's just a question of predictably. People, in order to explain away a decision that they find inexplicable, are going to go to the personal attributes of the judge. They're going to say, ah, yeah, appointed by Jimmy Carter, left-wing activist judge on the bench who was looking for any way to justify his foregone conclusions to dismiss this lawsuit to protect big media outlets. And this is the type of speculation that can never be proven nor disproven, which is why I sort of try to avoid it myself on my channel, but it's predictable. And then you have other people saying that this type of corruption is exactly why you should never have judges appointed for life. They're political appointees, or they get too old to do their job properly, etc., etc. The flip side to that, however, is that while federal judges are appointed, you do have elections for judges in the United States. And both of those systems carry with them the risk of corruption. Political appointees always carry with them the certain risk of political corruption, or political influence, or political favoritism. And we have the same thing in Canada. Judges appointed by liberal prime ministers versus judges appointed by conservative prime ministers, they will always lend themselves to accusations of political bias in the judgments they render. But compare that to the situation where you have judges that are elected by their constituents. And then you won't have political pressure, but you're going to have social pressure. You're going to have electoral pressure. You're going to have pressure for the judges to render decisions that are going to satisfy the people that elect them to office. That entire process carries with it the exact same fear of corruption or undue influence. It just materializes itself in a different way. An appointed judge might be beholden to the political party that appointed him or her, versus an elected judge is going to be beholden to the constituents that elected him or her, all of which may influence the decisions that that judge is going to render. There is no perfect system, and both systems carry with it the risk for corruption. The only question is which one carries less of a risk of corruption. But again, accusations of corruption tend to fly less when the process itself looks like it has been fair and equitable to the parties. And then you have a lot of internet talk of people saying, well, let's run some negative and defamatory articles about the judge, but let's just qualify it as opinion and not fact, because that was one of the questions in law in the judge's decision. Opinion cannot be defamatory because it cannot be demonstrably proven false. That, I am firmly convinced, is an error in law that the Court of Appeal will deal with. But you have a lot of people jokingly or not so jokingly saying, let's run defamatory articles about the judge, qualify it as opinion, and then say, well, you can't sue us because of your own judgment. Opinion cannot be defamatory because it cannot be proven false. And a lot of it is internet chatter, things people say on the internet that they wouldn't necessarily say or do in real life. But that type of rhetoric leads to a situation that is just as problematic as the situation that people are complaining about. And I want people to appreciate this fully. A judge rendering a decision out of fear is no less corrupt than a judge rendering a decision for a bribe. The judicial process, the entirety of the judicial process, has to be fair and equitable, and that means that judges have to be free to make mistakes. There is a basic tenet of the judicial process to the effect that justice is human. Humans are imperfect, humans make mistakes, and judges are going to make mistakes. But a just and fully functional judicial system means that a judge, unfortunately, has to be free to make mistakes. If a judge feels compelled to render a decision out of fear, that is just as bad as a judge feeling compelled to render a decision because he or she is being bribed. And reading through the comment section, the sentiment was virtually universal. I have people saying that they are left-leaning people and were still surprised by the decision, and then I see tons of comments from people accusing this judge of being a liberal activist judge, too old to be sitting on the bench, arguing from a foregone conclusion as opposed to towards one. But the sentiment seems to be virtually universal that this dismissal of the suit on the stage of a Rule 12 motion to dismiss was premature, to say the least, and when people see what they perceive to be injustices, they start looking for explanations to explain that injustice away. And yeah, we're going to be following this decision because if the Court of Appeal maintains this ruling, it basically seems like it might absolutely eviscerate everything that exists of defamation law in the United States. If statements of opinion cannot qualify as defamation, we're going to be living in a world where anyone can say whatever they want and say, well, that's my opinion, you can't sue me. But I'm absolutely going to be following this decision. I'm going to follow it to the Court of Appeal. I'm going to follow it to the merits. My prediction is that the Court of Appeal is going to overturn this decision because this decision reads like a judgment on the merits. It reads like a judgment that has analyzed all the evidence and came to conclusions of fact based on evidence. It does not read like a decision that analyzes and answers pure questions of law. Period. 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 Alright, so I hope I answered enough of your questions and got to some of the recurring comments in the comments section. I gotta go inside, I'm sweating like an absolute pig. If you like my content, you like my channel, please be sure to like, share, subscribe, hit the notification bell, leave a comment, share my channel with somebody you know, and at the very least, now you know your vlog. Peace out. Boom!